Recently, we had a young couple come to us with two minor kids, and they really didn't know where to begin with estate planning. Let's just call them Aaron and Andy. They had no documents, which means they had nothing in place, but they wanted 100% protection in the way that that meant for them. We see this circumstance play out every day. So starting from the ground up, what did we put in place for them, starting with nothing and now with a comprehensive estate plan? Aaron and Andy are a married couple here in North Carolina, but they're not from North Carolina. In fact, each of them moved here from other states for their jobs or to pursue careers. And while here, they had two kids. Their kids are now 12 and 9 years old. Currently, they have no estate planning documents in place, but they're both financially savvy. They're both very smart, but they both know that it's gone far too long without an estate plan, and they don't want to go another year having had nothing in place. They're important people. Their siblings, their parents all live in other states, but are responsible, respectful, mature, and very capable to serve in all the roles that we need them to serve. But the fact that they don't live here in North Carolina creates a level of complexity. So a few things happening here. Young couple, young kids, very responsible, but nothing in place. We have a whole group of individuals that could take over in that event of crisis, whether it's known or unknown, chronic or critical. But the planning documents just aren't there. Their top priorities in creating an estate plan is to name the right people to care for their kids after they're gone, legal guardians. Making sure that the kids are protected if something happens to the parents while the kids are still young, and making sure that everything is easy and organized should something happen to them, that they're not getting bogged down in process for the sake of process in this otherwise crazy scenario. Aaron and Andy want a plan that's going to be easy, flexible, and allow their family, their kids, and the loved ones that they will empower to take over in their absence to be able to move forward without probate, without issues, without hassle. Without a plan in place, there is no structure, there is no guidance, there is no clarity on what would happen next. It all falls to the court administers processes of defaults. There's intestate succession through probate, and there's court-appointed guardianship if the kids are still minors. Assets get bogged down in probate. Important people are unable to serve because they live in another state and don't live here in North Carolina. We're also not solving for incapacity issues or appointing intentional people to be able to serve for us. So if either Aaron or Andy get in an accident, or heaven forbid they both get in an accident during periods of incapacity, their family will have to apply for guardianship to be able to make decisions for them. And it'll be through a more drawn out and burdensome process instead of acting immediately as soon as they hear that there's been an accident. Even further, Aaron and Andy probably have a choice that they'd actually prefer to be the guardian for their kids. But instead, the court will have to decide among many different potential next of kin as to who is the right person to serve in those roles. And of course, the court doesn't know anything about Aaron and Andy's family members, the goods or the bads. And so they'll have to learn all of that in real time to make a decision as to what's best for the kids. And if Aaron and Andy have their retirement accounts, their life insurance, and their assets beneficiary designated to their minor kids, those assets cannot be owned directly by minors. And so they will also be subject to a guardianship until the kids are 18, and then they'll be able to get it all at once, right away at 18. So the solution to all of these problems, given Aaron and Andy's circumstances and their goals, is a comprehensive estate plan. We put in place a joint revocable trust plan for Aaron and Andy, and it's going to do many things for them. First, it's going to hold their real estate during their lifetime to make sure that if something were to happen to Aaron and Andy, that house can immediately be sold without having to go through any sort of court filings or notice to creditors periods beforehand. That's going to be very powerful because if Aaron and Andy's kids live here in North Carolina, but the guardian lives in another state, the kids are probably not going to stay in that house very long. So the house ends up being a trapped asset. It's cash stuck in the form of real estate and fixtures rather than being able to be reached right away to be used for the kids' benefit. The trust is also going to be able to set forth structure and rules and control as to what's supposed to happen to all of these assets if Aaron and Andy pass away while the kids are still minors or young adults. So we don't have all at once wealth transfer to kids who are not ready for it. We're also going to be able to avoid probate and guardianship proceedings for any assets that may be transferring to the benefit of Aaron and Andy's kids. We do that by beneficiary designating the joint trust on their beneficiary designations instead of the kids directly. So if the kids are still minors, they're not getting it directly. The trustee that's been appointed for that trust is going to receive it instead and hold it for their benefit, paying for things like health and education, maintenance and support until the kids have reached a certain age that Aaron and Andy choose themselves. Aaron and Andy are also going to create what are called pour-over wills. Pour-over wills are last will and testaments that are meant to just name their trust as the beneficiary of any assets that end up in their estate, probably because they fell through the cracks. We didn't know that we owned them. We didn't get around to retitling them. The pour-over wills are also going to name guardians for Aaron and Andy's minor kids if they were to pass away while either or both of the kids are still minors. That's going to allow Aaron and Andy to promote or appoint the people that they have in mind to raise these kids in their absence, rather than just letting the courts figure it out after they're gone. Estate planning is the opportunity to remove people from the ability to serve for you by appointing people that you actually want to serve. They're also going to create durable powers of attorney for financial and healthcare purposes to solve that issue of incapacity and protect their rights, advocate for them in the event that they're not able to advocate for themselves. Again, avoiding the court process of guardianship by appointing people that they choose to be able to act right away if both Aaron and Andy are incapacitated, can't make their own decisions. That's going to be really critical to make sure that the bills continue to get paid, that the kids are otherwise financially cared for, and that medical decisions are being made for Aaron and Andy in real time, instead of waiting for the court to get back to us and appointing a guardian from whoever has applied for that role. Along the way, after this estate plan has been signed and is in place, it is revocable. So Aaron and Andy can make decisions to change the terms of these tools over time as their kids get older and show them who they're going to be, whether they're mature or immature, whether they've made some good choices or poor choices, or whether they've married the right person or the wrong person from Aaron and Andy's perspective. We can also continue to provide ongoing email and phone support for Aaron and Andy over time to help them navigate these different decisions. If Aaron and Andy ever move, we're able to make sure that assets are consistently aligned to be part of their estate plan and not fall out by the wayside. Over time, consistently making sure that the estate plan is up to date and that assets are in alignment, make sure that this estate plan is always going to do what they want it to, not just did a really good job creating it in 2025 and then it becomes stale over time. This is how we made Aaron and Andy's reality from totally unprotected to the ideal possible outcome for them. Creation of an estate plan, full implementation. It's time to take control of your legacy. Click the link below to start the process.